Welcome to the Jay Tyner Show, where we discuss all things wealth management and retirement planning. And as always, the goal of our team here at Semmax Financial Group is to help you focus more on your life and less on your money. Now, as a reminder, check with your current advisor, planner, CPA, and read our disclosure in the video description below. Subscribe to this channel if you want to stay up to date on all of our new content. And by the way, if you have questions or need a 15-minute free consultation, please visit semmax.com or call 336-856-0080.
Hello and welcome. My name is Matt Landon. I'm joined by Mr. Michael Sellers, CFP, and we're here to talk to you about the top 5 estate planning must-haves. Now, I'll go ahead and tell you right off the top, neither one of us are an attorney. I'm not giving you legal advice, but I would say these are 5 key things that you need to have addressed. You need to talk through with an attorney. You need to make sure you have a plan and you've got them figured out. So right off the top, number 1, wills and trusts. Take it away.
Right. So will is going to be your kind of base, most important document that you can do. You would like your will to be drawn up by a licensed attorney in your state. But that's going to be where you bequeath assets to your heirs, children, relatives. You can list things out. It's a very important document to have, and it does not avoid probate, but it gives the judge instructions on how to divide assets.
So a will just really says who gets what.
Right.
How does a trust differ from that? I thought the trust might be the same thing.
Right. So a trust is going to typically be used for more specialized assets and how you want to long-term deliver assets to beneficiaries, or how you want them managed for down the road.
So a trust allows you to have a little bit more control over how things are distributed, when, timing. You can put some rules around it, however you like.
Exactly.
Right?
Exactly.
Yeah. Now, when it comes to a durable power of attorney, I would say this: a durable power of attorney is a legal document that allows someone to be able to do things on your behalf. So say you need someone to write a check because you're in the hospital, or take care of some of your financial things while you're suffering from a diminished mental capacity, those types of things. A durable power of attorney is able to step in and fulfill that obligation. Now, here's what I would say, and this is just a caveat: if you've got a spouse or something like that, that's probably your first bet for being your durable power of attorney. What I wouldn't suggest doing is having a child on your checking account. I think a durable power of attorney is the way to do that. You want to go through the attorney, have the legal documents drafted that you needed to make sure things are done appropriately. Now, what about beneficiary designations, and how can you run into some thoughts around that?
Right. So beneficiary designations are as, if not even more important to your will. And the reason is, anything that you name a beneficiary on overrides the instructions in the will if they differ. Mm-hmm. And so if they are different, you're asking for trouble in will contestations and things like that. Somebody could contest what says what the will says.
So if your brokerage account says these 4 people are getting it, it just goes to those 4 people. It doesn't matter what your will says about your brokerage account.
Right. So typically where you name beneficiaries are going to be obviously life insurance contracts, any contract with an insurance company, such as annuities, things of that nature, and of course qualified accounts. So your 401k, your IRA are the primary places people need to name beneficiaries, and contingent beneficiaries as well.
And somewhere along this line, you would say, well, what's the difference between my advisor and my attorney? If I've talked to my attorney, why do I want to talk to my advisor? Well, your advisor might say, well, your will, you're wanting to leave $40,000 to the church. If you take that out of your IRA instead, that's going tax-free. You might have tax consequences to your kids. I think you want to make sure your legal and your financial is married up. Right. And I know that's something that you feel very strongly about.
Right. You definitely want to coordinate that. And so we'll work closely with your estate attorney in making sure the beneficiaries are set up properly. If it's a non-qualified account, transfer on death instructions, things of that nature as well.
Yeah. Now, your healthcare power of attorney, that one is in some ways similar to your durable power of attorney. And you might say, wait a minute, why do I need 2 power of attorney documents? Well, your durable power of attorney speaks to more of that general financial. The healthcare is specific to your healthcare, and you may want them to be the same person, but you may want them to be different. You might be in a situation where you say, I have 2 kids. One of them has a great business mind, but I don't want them making decisions when I'm in the hospital bed, right? And you may have another child who you say, you know what, they're a compassionate soul and they live right down the street and they're going to have no problem taking me to and from my doctor's visits, but I don't necessarily want them in charge of my financial side of things. The healthcare power of attorney, like I said, is much more healthcare driven. The durable's the other. So these are both documents that have value, and there's not overlap in them. Now, guardianship designations. Why don't you touch on that a little bit and give some thoughts around it?
Right. So guardianship comes up with minor children. So if you have one or more minor children, you can't just leave money to them. They're not going to be able to manage the funds until they're 18 or older in most states. And so you want to be very careful and name a guardian, and even a contingent guardian as well. Someone who's responsible, who knows your family, who you trust, and that they could help get the kids through college or whatever the money is purposed for. So primary and contingent guardian for minor children is important to name.
I think that's a great note to end on. And I would also just say this: if it's been a few years since you've updated your documents, maybe those minor children are now 23 and 24 years old, and things maybe need to be revised. I would also say about every 10 years, it's important to pull out those documents and look at it and see what kind of changes have been made. I can tell you for a fact, 15 years ago, I was not thinking about my digital property and making sure that's part of a will. Well, that's something you may want to consider now. And so I would say if you haven't done it, it's a good time to pull things out, refresh, make sure you have the documents you need. But do you have any final notes you'd like to close us out with?
No, I think that's it. But just, take the time, name beneficiaries. If you haven't updated your will, at least do that, and match your will wishes to your beneficiaries on all of your accounts.
Wise words. I think these are unpleasant conversations, but they're good conversations to have, and it's better to do it before you need it. So on behalf of Michael Sellers, and I'm Matt Landon, wishing you a wonderful afternoon, and thanks for watching.